Hello and welcome to another lecture of the Law of the Sea. I am Muhammad Tahmidul Islam, lecturer, Department of Law, World University of Bangladesh. And this lecture has been produced as part of the online learning system of the Department of Law, World University of Bangladesh. So today we are going to talk about international straits. A strait is a natural waterway, a contraction of the sea between two territories being a limited width. So, strait is a natural waterway through which ships and other kinds of sea vessels can go. An international strait is a strait used for international navigation between one part of the high seas or an exclusive economic zone and another part of the high seas or an exclusive economic zone. The definition comes from Article 37 and 38 of the 1982 United Nations Convention on the Law of the Sea and includes both straits which at some point are overlapped by the territorial seas of the bordering state or states and those straits through which there is a continuous corridor of high seas or an exclusive economic zone. There are in the world over 200 waterways which would appear to satisfy the requirements of being an international strait. So here I have provided an example of a strait. Here we can see this landmass is Iran, and this is actually the strait, the Persian Gulf and the Strait of Hormuz. So this narrow area, which is actually less than 30 kilometers, this is called the Strait of Hormuz, and this is an international strait which works as a passageway for ships and vessels. According to the Law of the Sea Convention, a regime of transit passage, According to the Law of the Sea Convention, a regime of transit passage prevails with regard both to ships and aircraft through an international strait that is overlapped at least at its narrowest part by bordering territorial seas. Transit passage which shall not be impeded means the exercise of the freedom of navigation and overflight solely for the purpose of continuous and expeditious transit of the strait. So in the strait region, we see that the freedom of navigation and overflight prevails. While in transit passage, ships and aircraft must avoid any threat or use of force against the sovereignty, territorial integrity, or political independence of the state bordering the strait, and refrain from any activities other than those incidents to their normal modes of continuous and expeditious transit unless rendered necessary by force majeure or by distress. So in that strait region, any other kind of ship or aircraft can go through, but it should be for peaceful purposes. It should not threaten the interest or threaten the sovereignty of the bordering country. Vessels in transit must comply with the generally accepted international regulations, procedures, and practices for number one, safety at sea, and number two, the prevention, reduction, and control of pollution from ships. So these must be regarded highly while transiting through a strait. The airspace above international straits remains open at all times to transit passage. Such passage must be continuous and expeditious and must be undertaken in the normal mode of flight for the respective type of aircraft. So airspace above the international straits are open, but it should be normal, it should be general, and it should be peaceful purpose. It should be, of course, for peaceful purpose, because if a country uses spy planes or uses military jets to threaten another country bordering the strait, that country has the power to expel those aircrafts from that region. The aircraft must refrain from any acts of hostility, but may engage in activities that are consistent with their security and the security of accompanying surface and subsurface forces. So, security wise, Airplanes have radars, airplanes have their security measures. So in general transit, though, airplanes can use those radars and their security measures. A state bordering an international strait may adopt laws and regulations relating to the loading or unloading of any commodity, currency, or person in contravention of the customs, fiscal, immigration, or sanitary laws and regulations of the bordering state. So, in that case, we see that in the strait region, the bordering state can apply its laws regarding the loading unloading of commodity, currency laws, fiscal laws, immigration laws, or sanitary laws. So this kind of laws can be applied by the bordering state. According to the Law of the Sea Convention, there are two additional duties of a state bordering a strait. Number one is that it to give appropriate publicity to any danger to navigation or overflight within or over the strait of which it has the knowledge of. So, if the bordering state knows that a strait or a passageway is very dangerous for ships, it should notify all ships in the area that this passageway is very bad for you. Please do not go there. If they do not make other ships aware, they will be responsible for the losses. The second is that it should by agreement with user states cooperate in the establishment and maintenance of necessary navigation and safety aids or other improvements in aid of international navigation. So secondly, in that strait region, in order to facilitate proper management of that strait, in order to facilitate the proper usage of the strait, the neighboring country or the bordering country can implement measures by partnering with other countries that use that strait. So, international strait is a unique unique type of um, sea passageway which are usually very narrow and which fall within the actually territorial parts of different countries. But these parts are so important for international travel and international transit of goods that they should have uh, specific rules regarding them specifically, so that international law is straightforward about that section. So international straits are very important parts of international law of the sea. I hope you've understood the lecture contents, and if you face any problem regarding understanding the lecture, please contact me. I will answer accordingly by your comments. Thank you.